Thank you so much for joining me, Frank Zawicki, Programs Manager here at Family Promise of Sussex County. I do apologize if we've been unable to edit out some of that beginning information. I do really sincerely apologize for that. Um, we've had some real technical issues trying to present this information. We're not tech wizards here. I certainly am not, but I have some lovely folks, at my disposal, some colleagues here who have been helping me. So thank you to them, Tori, Jamie, Dawn, and helping, put these lovely presentations together, some great slides so that we can present this to you. So stabilizing tenancy, eviction prevention program. So STEPP, stabilizing tenancy, eviction prevention program. This is a grant-funded program from the New Jersey State Bar Foundation, so just want to give a quick nod of recognition to them. Thank you so much with the deepest and most sincere gratitude. We are so grateful for the grant funding that allowed us to present this information. So STEPP, or Stabilizing Tenancy Eviction Prevention Program, is a landlord-tenant informational session or series. They're courses dealing with different topics involved in landlord-tenant law. And just gonna shut my window for a brief moment. Got all kinds of trucks beeping and stuff. But STEPP is devoted to, it's a series that we are providing information to our clients, to landlords, tenants, attorneys, area service practitioners, anybody who wants to be part of the solution in creating a better, more peaceable, civil landlord-tenant transaction. So at Family Promise, we are a housing agency. We're a nonprofit 501c3 agency devoted to helping people with diverting eviction by either paying the rental arrears owed or by helping folks relocate or rehousing people who are dealing with the crisis of street homelessness. So again, thank you so much to the New Jersey State Bar Foundation for allowing us to provide this information, because in the course of my work, going to court, working with different legal practitioners and court staffers, landlords, tenants, I've been able to learn a lot about landlord tenant law, and it's allowed me to, convey this information to you today. So that's why I'm here. This is our tenant eviction session. So this is basically from beginning to end what it's going to be like for anybody who is a tenant. You find yourself in the eviction process. This is what it's going to look like, from the grounds to being evicted, to pretrial notices, to any tools you may have in your pocket before trial. If you proceed to going to court, what trial looks like, and what some of your remedies are there, and things like that. So wanted to present that we're going to present that information to you in this video now, and then I'm going to stick around. And so you'll have the opportunity to view this video, enjoy the slides and the information conveyed, and then we're gonna, I'll be available for a live Q&A session afterwards to answer any questions you may have. So again, this is STEPP, Stabilizing Tenancy Eviction Prevention Program, presented or funded by the New Jersey State Bar Foundation. And today we're talking about, if you are a tenant, what the eviction process is like. And I am presenting it as Frank Zawicki, Programs Manager, Family Promise of Sussex County, and really happy to do it. So wonderful that you can join me, and I hope you enjoy the material. Let's go ahead and get started. So real quick, before we get to any substantive information, we want to just quickly let you know that Family Promise is not a legal service provider. We are a housing agency. We are case managers. So as I explained before, we help people dealing with the crisis of housing, and we also help people with diverting eviction who are struggling to pay their rental arrears. So we are not legal counsel. We cannot give you legal advice. So this is just meant as informational. If you have any questions of a legal consequence, please reach out to a lawyer, whether it's a private practitioner, if you can afford one, or if you have to call your county's bar association and ask for their lawyer referral service for any pro bono or free practitioners, or Legal Services of New Jersey, or in our area, Legal Services of Northwest Jersey, which is just a branch of Legal Services of New Jersey. They have excellent, low cost to free legal service representation. Okay. All right. So let's jump right in with the material. So if you have a right to a court process, so just to let you know right up front, nobody can remove you from your home physically. Your landlord cannot, cause or institute any action against, what they can't, so they have to go through the formal legal process, the litigation process. They cannot physically remove you from the property. They cannot intimidate you into leaving. They cannot do illegal lockouts. They can't change the locks on you. They can't, shut off your utilities. They can't, hold your furniture, your clothing, your property in exchange for rent. They can't, barter. It's basically, They cannot do that. They cannot institute that. They cannot physically remove you from the property. The only people that can physically remove you is a special civil part officer who has been appointed by the court, and that is only after you have had your entire process seen and done. So you have to go through the entire litigation process, from being served with notices to being served with your summons and complaint, going to trial, having a judgment of possession entered against you, and then your landlord can file for what's called a warrant of removal. And only at that time can a special civil part officer remove you. Only when you have a lockout date and you refuse to move, then a special civil part officer can physically remove you from the court. But even after you've gotten judgment of possession entered against you, a warrant of removal issued, even then, the landlord themselves, him or herself, cannot physically remove you from the property. Only a special civil part officer can actually physically remove you from the property. So that's just something to know going forward. Okay. And this slide is in regards to using eCourts. eCourts is an excellent digital system. It's a web-based system. We're going to have a separate video that's going to come out about that because I want to devote some specific time to that. I don't want to get into too many nuances about eCourts today, but eCourts is a wonderful system. I would suggest looking into it on your own if you don't get a chance to look at the eCourts specific video. But eCourts is an electronic database. So if you have been served with a summons and complaint and you have a docket number, meaning that that is a serial number, basically, that is a series of letters and numbers that have been assigned to your case that helps identify your case in landlord-tenant court. So if you are actually being sued for eviction and you have a case in court and you have what's called a docket number, you can put that into eCourts. You have to create an account. You can put your docket number in, or you can put your name into eCourts, and then you can use that to generate information about your case. So you can look up the most updated postponement or adjournment information, if there's been any important rulings with regard to your case, if there's anything that you need, if you lost the paper information and you need the most updated information with regards to your case, it will be digitally filed by the court via eCourts, and it's a great way to track and organize your case. So we're going to have a separate video on how to create an account and how to utilize eCourts so that you can stay organized in following your eviction case. Okay, so that's to come. So again, now going back to what we were originally talking about, not only can a landlord not perform illegal lockouts, but there has to be specific grounds for eviction. So a landlord cannot just, on a whim decide, hey, I don't want to rent to you anymore, so I'm going to evict you. It doesn't happen. So first of all, New Jersey is one of the most tenant-friendly states in the country. And a landlord has to establish what is called just or good cause in order to evict you. They can't just evict you for any whim that they feel like. They have to establish what is called good cause. There is legislation that is called the Anti-Eviction Act in New Jersey. And there are specific reasons in the Anti-Eviction Act for why someone can be evicted. So your landlord has to establish those reasons. But backing it up, you hear these words that we've been talking about, like special civil part, things like that. So we'll get into that, so I don't want anybody to get confused by judgment of possession, warrant of removal, things like that. I will explain what all of those processes are, or what those definitions are, as we go along the way. But first, as we briefly recap what we've just covered in this very short amount of time, we have talked about and said no one can perform a lockout, no one can physically remove you from the property except a special civil part officer. What is special civil part? So special civil part just simply means that is the part of the superior court. So when you are being evicted you're sued for eviction, your landlord is going to court, and it is in the special civil part. So your case will be heard in what is called superior court in your county courthouse, and then you will go to the civil division. But in the civil division is what's called the special civil part. And in special civil part, there is small claims, there's district court, and landlord-tenant court. In landlord-tenant court, your landlord is specifically seeking one remedy from the court. They're going to the court and saying, Judge, I want possession of the property back. And that is what they're asking for. So special civil part just means that they are cases that are heard and disposed of very quickly. There's not a lengthy litigation or discovery process that usually could last up to years. Here, a typical landlord-tenant eviction case is disposed of within 3 to 4 months. But in landlord-tenant court, your landlord is going to the judge and saying, I need a ruling, an official ruling from the judge that says, I get this property back. I want the property back. And that's what judgment of possession is. It is saying, Judge, I need your judgment. I want possession of the property back. And if you lose your case, the judge is saying, landlord, you get possession of the property back. So that's what judgment of possession is. It's the ruling from the court that gives possession back to the landlord, okay? But before they even get there, again, as we said, they can't remove you themselves. They can't perform illegal lockouts. You have to have your due process, and even having your day in court and having all of that litigation process, you still, only a special civil court officer can remove you. The landlord cannot remove you themselves. But they also first have to establish the grounds for eviction. So as we said, the Anti-Eviction Act of New Jersey the landlord has to establish just or good cause for evicting you. So non-payment of rent is certainly a good one. Disorderly conduct that disturbs other tenants, damage or destruction of the landlord's property, violation of the landlord's rules and regulations, violation of the lease agreement, violation of a public housing lease provision prohibiting illegal use of drugs or other illegal activities, not paying a rent increase, housing or health code violations. Now, again, with not paying a rent increase, there are just not paying the rent increase is not going to be grounds for eviction in and of itself. We talked with Sarah Webb during our rent increase episode, our rent increase class or presentation. Sarah Webb, a wonderful attorney, a managing attorney from Community Health Law Project. Thank you, Sarah, for that lovely presentation. We talked about how there has to be a proper notice of the rent increase, and it has to be a reasonable rent increase as well. And then there's rent controlled townships as well. So just not paying the rent increase isn't in and of itself a grounds for eviction. But that is certainly the remedy. If you don't pay the rent increase, the landlord can take you to court for non-payment of the rent increase, and it will be the court's determination as to whether there was proper notice, as to whether that rent increase was reasonable. So there's a whole process to everything, right? But that certainly could potentially be a grounds for being evicted. I just wanted to make a quick point on that. Housing or health code violations, landlord wants to permanently retire the building from residential use, not accepting changes in the lease, paying rent late month to month, or what is called habitual lateness, conversion to condo or a co-op. Owner wants to live in the unit. The tenant loses the job that includes the rental unit. So, for instance, for those of you who may have a job where you are a handyman or a handy person at a apartment complex, and part of your job was that you got a free apartment to live in while you performed your job or your duties on that property. You lose that job, well, that apartment was part of your job, your benefits, your pay. So obviously you're going to be evicted if you lose that job. Okay. Conviction of a drug offense, conviction of assaulting, attacking, threatening the landlord, engaging or being involved in drug activity, theft or assaults or threats against the landlord, conviction of a drug or theft offense, human trafficking. So these are all specified reasons in the Anti-Eviction Act as to why, or those are the grounds that must be established in order to be evicted. So now, just establishing those grounds, you also are entitled to due process. You are entitled to notice. So the first thing that's going to happen is, again, remember, your landlord cannot remove you themselves from the property. They have to, one, identify just or good cause for why you should be evicted. So the first document notice that you'll receive that lets you know that you've been engaging in activity that will cause you to be evicted is the notice to cease. So the notice to cease is the first document received. And that basically says, hey, look, if you don't stop this behavior, you're going to be evicted, but if you stop it, you won't be evicted. So that's basically what a notice to cease is. It's a formal document coming from your landlord or their attorney that says, hey, in the example, the most commonly that we see is non-payment of rent, not only at Family Promise of Sussex County, but in landlord-tenant court in general. Non-payment of rent cases are the most common way to get evicted, and it's what we see most commonly in court. Notice to cease. So the first thing it says, hey, you haven't been paying my rent. If you keep not paying the rent, you're going to be evicted. But if you pay me all that's due and owing, you won't be evicted. Very simple, right? That's the notice to cease. Now, if that behavior does not stop, the next notice that you will receive as a tenant is what's called the notice to quit. Okay. And the notice to quit is basically, we told you to stop this certain behavior. You didn't stop it. So now we are asking you to leave by a certain date. And if you don't leave by that date, we are going to pursue the formal eviction process, right? So the notice to quit is the document that notifies the tenant that he or she must leave by a certain date, or the landlord will take them to court in pursuit of an eviction, like we had mentioned just earlier. The notice must have a statement of facts, dates, times, acts explained of, etc., and the law the landlord intends to rely on in order to evict the tenant in court. A clear and specific vacate date must be listed in the notice. Okay, so the notice to quit can be given directly to a tenant. The notice to quit can be left at the residence with someone 14 years of age or older, or the notice to quit can be sent via certified mail. So again, you've been given the notice to cease that says, hey, stop this behavior or you're going to be evicted. But if if you continue this behavior, you're going to be evicted. But if you stop it, you won't be evicted. But let's say you continue that behavior. Let's say again, there's, a provision in your lease agreement that says no loud music after 8:30, and you've been told several times, hey, stop listening to loud music after 8:30. You're disturbing other tenants. Plus, it's a provision in the lease, right? But you don't do so, and they finally, after being unable to rectify the circumstances, they say, we've asked you to do so. Here are the dates, times, and examples of when you were in violation of your lease, when you disturbed other tenants. Here's the Anti-Eviction Act that says that I can evict you for for violating provisions in the lease, for causing disturbances to other tenants. And you got to be out by this date, or we're going to pursue an eviction. So that's what the notice to quit is. So at this time, again, this is the time to, reach out to your landlord and intervene and communicate. So this is one of the three lines that I'm always, discussing during these courses, whether I'm talking about a different topic that I've had guest speakers about, or as it pertains to tenants experiencing the eviction process. It is so important to communicate early and get involved with legal services of Northwest Jersey. So in those non-payment of rent cases, it may be difficult to retain counsel privately that have a specific cost. Certainly, if you can't pay your rents, it can be difficult or challenging to afford an attorney. So call your county's local bar association and see if they have a lawyer referral service for any pro bono or low-cost practitioners. Or Legal Services of New Jersey, Legal Services of Northwest Jersey. Excellent low-cost to free legal service. But get involved with them early. I see the mistake all the time where people wait until court, they're at trial, and they run up in the hallway to a legal service representative and they say, "Can you help me? I got to go into mediation right away, and I owe $10,000. What do you think I should do?" They're not going to be able to give you really comprehensive representation. Some advice at best, but glaring at best, because they're not going to have the comprehensive, thorough amount of time to have dedicated to your case had you sought their counsel early. So make sure you seek them out early. And if you find yourself, especially in those non-payment of rent cases, the time you should be reaching out to legal counsel, the time you should be intervening with your landlord is when you've lost your job, or let's say, you've missed a lot of days at work because you were sick and you find yourself struggling to pay your bills. That is the time to communicate. Don't wait till you start receiving notices from your landlord. You should be communicating early and saying, hey, listen, I can cover this month, but I just lost my job. Unemployment's going to take a little while to kick in. Can we work on an installment plan, right? And you should be reaching out to legal services ahead of that conversation so that you know how to assert your legal rights and that you are protecting yourself as best as is possible. So early intervention, communication is key, okay? But as a quick recap, we talked about, okay, your landlord, it cannot physically remove you. Only a special civil part officer can do so. Only after you've had the entire litigation process, your due process. Now, your landlord has to establish specific grounds for eviction, or what is called just or good cause. And then once they have done that, you are due your notices. So you need to be put on notice that you are doing something wrong. So first, your notice to cease, stop this behavior, or if you don't stop this behavior, you're going to be evicted. But if you do stop it, you won't. And then the notice to quit says, hey, we asked you to stop, you didn't. Here are the dates and times and specific acts we're referring to as to why we are evicting you. Here's the law we are referring to evict you. And if you're not out by this date, we're going to evict you. Now, at this time, if you've spoken to legal counsel, you've spoken to your landlord, if you have a defense to put on, maybe you've reached out to Family Promise of Sussex County. Again, another great time to reach out to a service provider early. This is the time where you have reached out to them and said, hey, I need help with paying the rent. That was a good time. That would be a good time to see if you can rectify the circumstances then and communicate with your landlord and see if you can set up installment payments. But do it early when your debt is much more manageable, especially for those non-payment of rent cases. But perhaps, at that time, that's a discussion you're going to want to make with the service providers, with your family, with a legal service representative and your landlord to say, hey, look, I've got all that's due and owing, so I'm not going anywhere in those non-payment of rent cases. Or, hey, I have a viable defense that I'm going to put on. My landlord is just retaliating against me because I asserted my right because this place is uninhabitable, and he's suing me now because I asserted my right as a tenant. So I have a defense, and I'm going to fight this. I'm going to stay. But let's say, hey, I owe way too much, and there's no way I can fight this, and if there's a reason where you believe that you're going to be evicted or lose your case, and your legal counsel has given you the advice to say that, hey, you've got a family member that's willing to take you on to help you crash at their place for a little while you find a new job, or you help get your affairs in order, that might be better than risking going to trial and having the eviction filed against you on your consumer report could be adverse or deleterious to your consumer report or your tenant score. So that could have a negative or adverse impact against you. And having a judgment of possession entered against you, if you lose your case, that could stay on your consumer report for up to 7 years. So you may not want to risk that, especially if you have some safeguards in place. But if you don't have anything and you need to prolong your stay, or if you have a viable defense, then after speaking with legal counsel and discussing with your landlord and family, you may want to pursue a trial. So if you don't leave, because you don't have to leave after receiving that notice to quit, they may be asking you and saying, if you don't leave, we're going to, pursue the eviction process if you don't leave by a certain date, but you don't have to leave. So if you decide to leave at that time, or, then so be it, but you can stay. So the next thing you should expect in terms of notices would be the paperwork that you get from the court. So you're going to get a summons, and the summons is going to let you know when your case is being heard, what date you have to go to trial, what courthouse to appear at, what courtroom to go to, what judge is going to be there. You're also going to get a bunch of really great information about your legal rights, about what a legal lockout is. You can't be evicted on a holiday, can't be evicted on a weekend. The area service providers, the nonprofit charitable organizations like Family Promise that can help you in those non-payment of rent cases. You're going to get a lot of really great procedural information. You're going to get, contact information about legal services of New Jersey and Northwest Jersey. And in there, you're going to get the complaint, and that's going to outline specifically why you are being evicted. In those non-payment of rent cases, it's going to outline the dates, the months that you are behind, and it's going to write down the fees, the attorney's fees, the late fees, the months that are owed, and things like that. So that's what's going to be in the complaint. And then you'll have your summons, which is the where and when, and all of that really great information that talks about tenants' rights. The summons, the court can mail you your summons. An officer of the court can deliver your summons. The summons can be left at the residence with a person of age of 14 or older, and the summons can be posted on your door. Okay, so let's go ahead and move on to the next thing. So what's next? So you get your summons. So one thing before you go to court, obviously, the things that we want to talk about are some tools that you have in your pocket. Again, early communication is really the key. So reaching out to your landlord and discussing things with your landlord is really important. So communicating with them, communicating with your legal counsel, communicating with their legal counsel is really, really crucial. So before, if you need a postponement, you need some time, that could be a tool in your toolbox. So that's one thing before you actually attend trial and appear for trial and things like that. One of your options is, if you need extra time, is a postponement, or what is referred to as an adjournment. So once you have received the summons, if you need more time, you can ask for a postponement or an adjournment from the court. You can also try reaching out to your landlord and their legal counsel to see if they will agree to an adjournment. If you are seeking an adjournment from the court, you should request it at least 5 days before the court date, or else it may not, and usually will not, be allowed without demonstrating exceptional circumstances. However, should some emergency arise that prevents you from appearing, even the morning of, you must call the court and explain your circumstances. If you do not appear without demonstrating good cause with proper notification, a default judgment will be entered against you. Okay, so this is absolutely crucial information to know. So this is why it's so important to have that communication with your landlord, to have that communication with your attorney. Hopefully you've gotten counsel early on. So make sure that you are aware of these factors and make sure that you exercise this. So again, if you need time, at least 5 days before your court date, reach out to the court directly, or reach out to your landlord and their counsel and try to get some kind of adjournment, which again is just postponement if you need a little extra time. Little tidbit, if you're working with Family Promise of Sussex County or another area service provider, you can submit that to the court at your trial date. If you can testify on the record, have your case manager testify on the record, or submit your application, the court can grant you a little bit of time too if you're trying to put some money together in those non-payment of rent cases. So an adjournment is a way for you to get your ducks in a row, organize your case, and buy yourself a little extra time. Another tool that could be available for you is a settlement. Settlement is basically an informal way to come to an agreement with your landlord, their attorney, and hopefully your attorney if you reached out to them early. Because again, remember, and I may not have mentioned this yet, but I've mentioned it before, that your right to counsel in a civil trial does not attach as it would in a criminal trial. So we've all seen those cop shows where, someone getting arrested, they say you have a right to an attorney, or if you cannot afford an attorney, one will be appointed to you. That doesn't happen in a civil trial. You do not have a constitutional guarantee to an attorney in a civil trial. Interestingly enough, they are discussing it, at the state level to see if in New Jersey there will be a constitutional guarantee to an attorney in landlord-tenant trials, but right now that's not the case. So get to legal representation early, okay? Legal services early. They got a lot of cases. The earlier you get in and do an intake with them, the better they can and sooner they can represent you. But if you have that representation, or if you don't, and you want to reach out to your landlord, you can do so before trial. So even after receiving a summons and complaint, you can always attempt to settle or arrange for an out-of-court agreement with your landlord. Just make sure that the agreement is in writing and that both you and your landlord fully understand the terms of that agreement. For example, if the complaint is for non-payment of rent, perhaps you can arrange to make installment payments until you are caught up. It is helpful to try and make these arrangements before trial because at trial, the judge does not have much leeway in the ruling. Basically, at trial, the judge in those non-payment of rent cases is, do you have the money or don't you have the money? At a settlement, you can try to draft an arrangement that is fair and realistic to both you and your landlord. But remember, when settling, you can construct terms that are more accommodating than would be a trial ruling. However, you should only enter into an agreement that is fair and realistic. Otherwise, if you cannot adhere to the terms of a settlement agreement, you run the risk of breaching it and ending back up in landlord-tenant court again. Okay, so those are just some tools. So as we recap the information we've been talking about, again, landlord can't remove you themselves. Only a special civil part officer deemed with the authority from the court after you've had your entire litigation process can remove you from the premises after you've been served with a warrant of removal and a lockout date. But that's only after grounds for eviction have been established. But even when the grounds for eviction have been established, you are due your notice. So you get a notice to cease first, you get your notice to quit if that doesn't resolve the matter. And then, of course, you don't have to leave after you get the notice to quit. And if you pursue the eviction matter, you stay in the apartment even after your landlord says, all right, you didn't leave, we're going to go ahead and move forward with the eviction. You get your summons and complaint. And then even before trial, let's say you've adjourned it, right? You've reached out to the court ahead of time. You want to make sure that you can try to see if you can settle the case before trial, make an arrangement, because that's the time to do it. Again, early intervention, early and often communication is absolutely super important. Okay. And one of the things too that's really important as I trek back to the adjournment thing, make sure, again, so important, communication, especially with the court as well. So emergencies do happen. Let's say you get a flat tire, you get sick, you're hospitalized the day of court. It really does happen. But again, you got to make sure either you yourself or someone representing you reaches out to the court and let them know. Do it early ahead of time if you can. But if you have to do it the morning of, there obviously has to be good cause and emergency circumstances. But if they are justified, still let the court know, because if they do roll call or they do what's called calendar call, you're not there. They enter what's called a default judgment against you, which is basically the legal equivalent of a forfeiture. So you basically just forfeited your case. And if you have a viable defense, that's a silly way to lose just simply by not showing up or not putting the court on notice that you're not going to be there. So make sure you notify the court that you need a little bit more time. Try to reach out to your landlord and their legal counsel that you need more time. And then, of course, you have the option of a settlement, and that avoids trial because, again, at trial, the judge doesn't have a lot of discretion, especially in those non-payment of rent cases. So now, let's say you can't settle at that time, you've exhausted your adjournments, and now you come down to trial. So you got to go to court. What's going to happen at court? So make sure you get there nice and early, okay? So try to get there 30 minutes early. Your summons may say that your case is being heard at 9 a.m. Get there at 8:30 a.m. Find parking, get settled in, settle into the gallery. And what's going to happen is the first thing that you're going to see is a video is going to play. So the video is going to be a judge reading the Harris announcement. After that Harris announcement is over. So the Harris announcement is basically the information that you're hearing right now in a much condensed 10-minute version. So you're going to hear a version of the Harris announcement. It's going to be a judge that says, hey, here are your legal rights. You can't be evicted on a holiday. You can't be evicted on a weekend. We're going to tell you about what order for orderly removal is, what an order to show cause is, what a hardship stay is. We're going to tell you that your landlord can't, commit illegal lockouts or anything like that. So these are, the things that they're going to talk about. And once that video ends, the judge, the in-person judge, is going to come take the bench. And this Harris announcement is so important that they're going to do it all over again. So in fact, you're going to get the Harris announcement 3 times. So you're going to get the Harris announcement written when you get your summons and complaint. It's going to have all of your tenants' rights and information in it. So that's going to be your written Harris announcement. You're going to get the video before court actually starts. So get there early so you can listen to the video. And then the judge in person who's overseeing the cases of that day, they're going to come out and they're going to do the Harris announcement all over again. So that's 3 times you're going to get the Harris announcement because it is so crucial to you understanding your rights. So pay very close attention to that. Get to court early so you can hear the Harris announcement. Then the judge is going to take the bench and reread the Harris announcement. Once that's over, the judge is going to instruct his court staff, the clerk, to call calendar, which is basically taking attendance, roll call for the court for the day. And again, make sure you're there. Make sure you are there ready to hear your name. They're going to call your case, the docket number. They're going to read your landlord, the plaintiff's name. They're going to use your name as the tenant defendant, and make sure you're there and say you are there. Because if you're not there, or let's say you are there and you miss hearing your name, you're not paying attention, or you show up late, now they may call the cases again, but why risk it? Why risk a default judgment? Again, get there early, right? If you can't be there, there's an emergency situation, put the court on notice. And if you have time, right, at least 5 days in advance, if you need adjournment, you need more time, let the court know. Again, communication is so important. What a silly way to have a default judgment entered against you, which again is just you forfeiting. Basically, a default judgment is the court saying, okay, well, the tenant didn't show up, so I guess they don't have a defense to put on. So here you go, landlord. Here's your judgment of possession. You get possession of the property back. And within 3 calendar days, that landlord can then take their affidavit, that paper that says they get possession of the property. They can go to the clerk's office and get a warrant of removal issued against you, and a lockout date will ensue. Okay, so silly way to lose your case. Make sure you're there early. Make sure you listen and pay attention for your name, and stand up there and make sure you let them know that you are there. So once all the attendance is taken, calendar call is done for the day. What will happen next is the judge will insist that everybody try to mediate one last time. And mediation is just settlement conference. So he's going to insist that everybody go find a place, go out in the hallway, go find a conference room, find a table somewhere, go try to settle your case informally, because they're going to give you one more shot to try to settle this case. And again, try to find fair and realistic terms. And again, hopefully you have had early intervention with legal services so that they can thoroughly represent you and give you comprehensive representation in your case and counsel. And they can go to that negotiation table and really know your case, know the facts, and maybe there's a viable defense you have. And they're going to say, well, look, we know you were given improper notice, or there are some procedural or constitutional deficiencies in the complaint, and we're going to go ahead and try to get this case dismissed unless you want to try to settle now. So they might have some bargaining power. So the more they know about your case earlier on, the better they can represent you. But don't run up to them the day of. I mean, certainly do if that's your option, if that's all you have. Do your best to get any kind of legal counsel or advice, but early intervention is key. But after attendance is taken, roll call, calendar call is done, last chance to settle. And again, you don't have to settle if you don't think the terms are fair and realistic, because if you can't adhere to the terms, if you're not going to be able to pay $1,000 a week to come up with the debt in addition to your base rent every month, then you can't do it. So you might decide, hey, trial's the better option for me. So you get that one last chance to settle. Often settling is a better way to go because you can draft terms that are more favorable to both parties. You can make installment payments. The judge doesn't have that kind of discretion, especially in non-payment of rent cases. Do you have the rent or don't you? So, but let's say you don't want to settle and you want to go ahead and move forward with trial. So, you go ahead and move forward with trial. And we just covered all of that in that slide, the court process, mediation, and what those are. So let's say you want to go ahead and go to trial. So trial basically is, it's like a trial. So the landlord is going to get the opportunity to call their witnesses and present their case. And then you get the opportunity to cross-examine those witnesses, right? Then you get to put on your case and put on your witnesses and direct examine them. And the landlord has the opportunity to cross-examine your witnesses. So it's just like a trial. And then the judge will make their ruling after they've listened to your case as to why you weren't paying rent or why you feel that you should not be in court. So right now, though, what we have is a list of potential defenses. Okay, so what we have is, so these, if you do end up going to trial, these are some defenses that you can raise at trial that are, not necessarily slam dunks in every instance, but what they are is that your case could possibly be dismissed with what's called without prejudice, meaning that the landlord, if they correct this issue, they should be able to refile their case and you're going to end up in court again. But you're going to buy some time. So take advantage of every tool that you have in your toolbox. So that includes trying, early communication with a lawyer and early communication with your landlord, making sure you know the Anti-Eviction Act and that your landlord has to establish good cause, that they can't just evict you for any old reason that they feel like, that they can't remove you physically from the property themselves, that you are entitled to notice, including a notice to cease, a notice to quit, that you need your summons and complaint, that you have an opportunity to settle, that, hey, if you want to buy some more time, you can seek an adjournment or what's called a postponement or what's called an adjournment. You have all these tools in your toolbox, including using family promise. If you are non-payment of rent case and you're working with us to try to have those rental arrears or that back rent paid, you can have your case manager testify on the record, or you can supply the court with a copy of your application to buy adjournment time as well. So again, from the beginning of knowing that your landlord can't physically remove you from the property or commit what are called illegal lockouts, to knowing that they must establish good or just cause, to knowing that you are entitled to pretrial notices like a notice to cease, a notice to quit, and what it'll look like if you do proceed with trial, including the summons and complaint, what going to trial looks like. And now, of course, these are some defenses. So these are some things that hopefully, if your lawyer has been involved with your case early on, or if you, by reviewing some of the information from STEPP, have learned these defenses. So these are just some quick defenses. We're not going to go through all of them, but we're going to just touch on some of the ones. So unauthorized practice of law. If the landlord is a corporation, they must have a lawyer representing them. So that is absolutely true. So in those cases, if your landlord happens to be a corporation that owns the property, if someone from the leasing office shows up that is not a duly appointed lawyer, a barred attorney representing them, they cannot be there. So the case will get dismissed. But again, it will likely be dismissed with what's called without prejudice. So once they get an attorney, they'll be able to go back to court. But again, this is a victory. Get these victories any possible way that you can. So if it means that it's gonna buy you some time at the property, and while you have that time, you can reach out to local area service providers like Family Promise and other surrounding service providers to try to come up with the rental arrears you might owe. Or if it's for something other than non-payment of rent, if you need to relocate, you need rehousing services, they can try to help you find affordable housing as well. So buying time is absolutely crucial. Okay. So failure to register under the Landlord Registration Act. So you check with the city or town clerk. So yeah, failing to register the property according to the town laws. So you want to make sure that the property has been properly registered. So if you find in your research, or your lawyer finds in the research, that the property was never registered, that could be a defense and the case will get dismissed. But again, once they register the property, they can then refile their claim and you'll be back in court. So it's a victory, but it's not an absolute dismissal of the case. Okay, improper or no notice. So if you didn't get the notice to cease or the notice to quit, you weren't put on notice that you were in the wrong, or you didn't get served with process, like you didn't get served with a summons or complaint, which is the next one. Improper eviction complaint. So if there's things that are listed, that amounts of money that are listed on the complaint that are wrong, or you never were properly given notice, those are defenses. Those are constitutional procedural issues that need to be raised by either yourself or legal counsel. Okay, the rent was already paid or can be paid on the court date. That's certainly a defense. Certainly in those non-payment of rent cases, when if you have the money, that's going to get that case dismissed outright, and that will be absolutely a dismissal of the case because hey, I'm being sued for non-payment of rent, but look, I've got the money, so this case should be dismissed. Okay. Um, and we've got a few of other ones. Failure to obtain a certificate of occupancy if required by the municipality. So, some municipalities or townships require a certificate of occupancy. So basically, it's from, the town saying that this place is habitable, which leads to the next one, failure to provide safe and decent housing. Now, my colleague, Don Hendershot, presented a class last week with Randy Yang, who's a staff attorney from Legal Services of Northwest Jersey out of their Morris County office, and they talked about habitability claims. So that is a very complex topic about how to raise a proper habitability claim, but you do have a legal right to have safe and decent housing. And if you withheld rent, because your landlord failed to make repairs that would allow you to live in safe and decent housing, that is certainly a defense, but it is a complex topic, and that is covered with our habitability class. So if you're interested in learning about habitability claims and Marini bonds, please, I encourage you to check out that habitability course that was presented by Dawn Hendershot, my colleague. Thank you so much for doing such an excellent job. And thank you for Randy Yang for taking the time out of his busy schedule and presenting that information. It was absolutely lovely and so informative and very valuable. So thank you for that. So, but that is certainly a defense, okay? And then, of course, we have retaliation. So, landlord who is suing you for eviction because you asserted your right as a tenant, and they've done so erroneously or illegally, that is certainly a defense that will get the case dismissed. So certainly, these are a list of defenses that are some of the common defenses. They won't always outright dismiss the case, much like paying the rent will. But there's some, again, just more tools to have in your pocket or in your toolbox. And we just discussed what the hearing will look like. So that's what this slide is regarding. So when you go to court again, your landlord, puts on their case and their witnesses, and you can cross-examine them, and then you put on your case and your witnesses, and your landlord can cross-examine them after you've, done your direct examination, and then the judge will make a ruling. Now, if you lose your case, you will have what's called judgment of possession entered against you. So you've gone through the whole process here, right? And you've decided, after your landlord has established grounds for eviction, and you got your notice to cease, and you didn't stop the behavior, and then they issued a notice to quit, and you decided not to leave at that time, you got your summons and complaint, you couldn't settle, you've exhausted your adjournments, you end up at trial, you didn't settle then, and then you decided, at trial, you try to assert some defenses, you try to explain yourself to the judge, but you find that it just didn't work out, and the judge enters, in favor of your landlord. So the judge will then come down with what's called judgment of possession. So again, now, money, in a non-payment of rent case, that's the remedy that will fix this, right? So in landlord-tenant court, a landlord is not asking for money from the court in most civil cases. Now, if they get judgment of possession against you and they get the property back and you still owe back rent, they can take you to district court or they can take you to small claims court and potentially garnish your wages and things like that and get a judgment, a monetary judgment against you. But in landlord-tenant court at this time, what they are simply trying to seek is possession of the property back. And what you're trying to do is stay on the property. Now, if you have the money, and you pay the non-payment of rent case, which is the most common way to get evicted, then that will dismiss the case. But if you don't have it and the landlord proves their case against you, unless you settled. Now, again, if you had a settlement agreement to make installment payments, but you failed to make those installment payments and you are in breach of the settlement agreement, you will also have judgment of possession. Your landlord can go to court and get a judgment of possession entered against you that way as well. So that is basically what the landlord is asking for. That's the relief they want. They want possession of the property back. Judgment of possession is given by the judge if you lose your case, and the landlord gets within 3 calendar days. They can then take that affidavit, that paper from the judge that says they get possession of the property back, and apply for a warrant of removal with the clerk's office. And the warrant of removal is, the final document, that comes from the court. That is, issued, by the court, and it, is often posted on your door, and that is literally that says that, hey, you got to be out, and that's when you get your lockout date. And that's when a special civil part officer from the court can actually remove you if you decide not to leave at that time. Okay, so that is what happens. That is the finality of it. Judgment of possession when you lose your case at trial, and then within 3 calendar days, your landlord can then apply for warrant of removal, and that is the document. That's the final document that says, hey, you got to be out by this date. But even then, even when you get those documents, you do have options. So you have what's called an order for orderly removal. So let's say your lockout date is the 25th. On the 24th, you can go to the clerk's office. They're very helpful, very smart, really wonderful people that will be there to walk you through the process. Very simple paperwork. You can fill it out. And they are, and basically what it is an order for orderly removal is you writing to the court and writing to the judge and saying, hey, I need 7 more days on the property. I need to get, my stuff together. I've got a lot of things to move out. And my situation hasn't really come to fruition yet, or I'm working with Family Promise of Sussex County, for instance, in those non-payment of rent cases, and we just need a little bit more time to try to, explore those county resources to see if there's any way we can pay this non-payment of rent case. So I just need a little more time, and they will give you that 7 additional days, on the property. And this is even after the warrant of removal has been issued. And it's usually you apply for the order for orderly removal if, again, you're right before the day before your lockout date, so you can really expand the amount of time you spend on the property. And then in order to show cause, it can be done, if after the warrant of removal has been issued. It can be done beforehand. It's basically, if there is some crucial element to the case that materially affects the outcome of the case that you need to get in front of the judge right away. That is what the order to show cause is. So it's another very basic, easy paperwork that you fill out. You go to the clerk's office, they will help you fill it out. And basically, you're writing to the judge that says, hey, Family Promise of Sussex County has all that's due and owing, and I need to get this information in front of you now so that they can pay the landlord. And the court will look at it. The judge will look at it that day and have a ruling that says you got 30 days to pay it. Or let's say in those cases where, hey, I have all that's due and owing, this is simply a non-payment of rent case. In those non-payment of rent cases, if that's all it is, it's just non-payment of rent, and you have all that's due and owing. Either you yourself have it as the tenant, or if you're acting through a nonprofit charitable organization like Family Promise of Sussex County, your landlord is compelled by law to accept that money. And let's say they're not accepting it. That is a good way to get that information in front of the judge, and the judge may then say, hey, we got to have a hearing, and I got to know why they're not accepting this money. Or they may issue a ruling that says, you landlord, you have to accept this money, and I am staying the warrant of removal until this is paid. So really great tools to have in your toolbox as well. And then you have hardship stays, and hardship stays are rarely given. That is the last tool in your toolbox, and that is for those cases that have nothing to do with the non-payment of rent. If someone is able, in fact, to demonstrate that they can pay their rent, but they show that there's absolutely no living arrangements that they can move into in the immediate area, then they can apply for what's called a hardship stay for up to an additional 6 months on the property. But again, very rarely given because the burden, the threshold is so high. Again, you have to, one, demonstrate that you can continue paying your rent. So it's not for those non-payment of rent cases. So you have to show that you can continue paying your rent, and that, there are absolutely, not that there's no affordable housing, there is absolutely nothing for you in the area. So it's rarely given, but you can use it to stay for an additional 6 months. That's called the hardship stay. So order for orderly removal, order to show cause, and hardship stay. And just to let you know too, if you do come up with the money for those non-payment of rent cases, if you happen to come up with the money even after a lockout, so the law states that you have up to 3 calendar days subsequent to a lockout. So even after being locked out, you have 3 calendar days to come up with the money. And if you do come up with the money within 3 calendar days after being removed from the property, your landlord by law has to reestablish your tenancy. So just another little tidbit of information that I wanted to provide you guys. So, and just finally to let you know that help is available. So again, as I've been communicating, early intervention is absolutely key. So help is available. Legal Services of Northwest Jersey, absolutely crucial. Please look them up. And Legal Services of New Jersey, and then of course Legal Services of Northwest Jersey. But get involved with them early. Communicate early when you're starting to have problems, especially in those non-payment of rent cases. Make sure that your landlord is aware that you're having issues up front, so you can try to draft some kind of resolution before it becomes litigated. And then, of course, Family Promise of Sussex County is certainly available to help in those cases where you need that money. So please, we have comprehensive eviction defense and diversion, homelessness prevention program, and a whole multitude of other programs that are prepared to help pay that back rent. So please reach out to us so we can do an intake assessment and try to help intervene. And we can work with legal services to try to help craft a defense and help you out. And of course, 211 can connect you to other area service providers. So please, early communication, communicate with your landlord, communicate with your legal counsel, reach out to area service providers. Help is available, and we can provide services like this to you now, this informational session. So I want to thank you. I know we whipped through that material rather fast. We wanted to condense this and make this, as short as possible while expanding on it as much as we could. But again, I'm going to be available for a live Q&A following this video, so I'll be able to expand on the topics that we just covered. So I want to thank you for listening to the video and devoting your time to absorbing this information. I know it's complex and there's a lot of information being conveyed, but thank you again for your time. I really enjoyed conveying it. Again, I will be available after the video for a live Q&A. Happy to discuss anything with you guys. Again, if it's of legal advice, we're going to have to refer you to legal services, but I'd be happy to expand on the information conveyed in this video. Thank you again to the New Jersey State Bar Foundation for allowing us this wonderful informational opportunity. We hope to see you again at more of our classes. Please stick around for the live Q&A. And once again, thank you so much for allowing me the opportunity to present this information to you. I hope you enjoyed it as much as I enjoyed presenting it to you. Thanks again. Bye now.